Hi, and welcome to More Human, More Resources, the HR podcast for entrepreneurs. I'm Vicki Brown, your host and CEO of Vidamaneo Enterprises. As a serial entrepreneur, I understand that having the right expert help has been critical to my success. That's why I'm dedicated to telling you, in plain language, what's going on in the world of HR that might impact your business and what you need to do about it, with real actionable tips to help you master that list of must-dos and grow your leadership muscle. First things first, the information contained in this podcast is provided for general purposes only and is not to be considered legal advice. Your decision to adopt or not adopt any practice or procedure mentioned in this podcast is solely yours, and we bear no responsibility for the outcome. We urge you to always consult legal counsel and other appropriate licensed professionals. And with that, let's get into the show. You're listening to Season 5, Episode 13. So, let's talk about a topic that frankly can make even seasoned HR professionals a bit nervous: I-9 compliance and dealing with Immigration and Customs Enforcement, or ICE. The question is coming up a lot right now. How can I prepare? What do I do if? First, let me be clear. Before you'd ever face an ICE enforcement action, you'll probably get an I-9 audit, and there are multiple ways these audits can get triggered. Sometimes another government agency reviewing your records might spot something concerning and notify immigration that a full I-9 audit is necessary. Or, and this surprises many business owners, you might simply be selected for an audit randomly. Yes, they can absolutely do that. Your business might be picked because of your industry, your location, a complaint from an employee or competitor, or various other factors that ICE won't always tell you. But once an audit is happening, several common errors might escalate ICE's scrutiny. Things like incorrect or missing employee information on I-9 forms, names, dates of birth, or work authorization status. You know, it's surprising how often these basic errors happen. Then there's using expired work authorization documents, which is a major red flag for ICE. Another big one is failing to re-verify work authorization for employees on temporary visas. Remember, if their authorization has an expiration date, you need to re-verify before that date arrives. And don't forget about proper storage. You have to keep I-9s for either 3 years from the date of hire or 1 year after termination, whichever is later. So, what's the best way to stay on top of all this? Well, the good news is that you can conduct your own in-house I-9 audit before some official does it for you. Appoint someone, whether that's you, another team member, or an HR professional, to oversee compliance. You can use the Department of Homeland Security's M274 Handbook for Employers as your guide. It's literally the rule book. I'll put a link in the show notes. Now, when correcting errors on existing I-9s, make sure you do it properly. Draw a single line through incorrect information, initial, and date the correction. Don't use whiteout or completely mark out the original information. That just looks suspicious. And since we're in an increasingly remote work environment, make sure you have a process for remote workers too. You can designate an authorized representative to complete the I-9 verification process in person, if that's what you need. Now, let's talk about what happens if ICE actually shows up at your business. There are different types of ICE visits, and it's vital that you understand the difference. Now, the most common is a Notice of Inspection, or NOI. This is where ICE provides formal notice to you requesting I-9s and related documents, typically giving you 3 business days to comply. This isn't a raid, it's a formal audit. Then there's a subpoena or warrant presentation. If ICE has a valid subpoena, you must comply. But have legal counsel review it first to make sure it's proper and so that you understand fully exactly what you're required to provide. And finally, there's the scenario most business owners fear the most, an actual raid or worksite enforcement action. ICE agents may enter unannounced, particularly in industries with a history of undocumented labor violations. So, what should you do if ICE shows up? Well, it depends on your type of business. For private businesses with non-public areas, know that ICE cannot enter without a judicial warrant signed by a judge. Not just any document, specifically a judicial warrant. You are not required to speak to ICE agents or allow them access to employee records without proper documentation. Politely, but firmly, request that they wait outside while you contact your legal counsel. For public-facing businesses like retail or restaurants, the rules are a bit different. ICE agents can enter public areas freely, just like any other customer, but they still need proper legal authorization to access non-public areas like offices or storage rooms. Make sure your employees know not to answer questions beyond basic identification without legal counsel present. If approached, they should remain calm and ask to speak to a manager or HR representative. Now, the consequences for noncompliance are very serious, so it's vitally important that you get things right from the very beginning, and that means have a plan. Have a designated person that's going to respond to an ICE visit. Request identification. Ask for the scope of the visit. If they're serving a warrant or subpoena, ask for a copy and immediately review it with your attorney, and then follow your attorney's advice to the letter. This isn't a time to be creative or rely on, well, I thought that was what you said to do. Be specific, exact, and precise. And stop talking. Say only what is absolutely necessary. Volunteering information isn't generally helpful for you. Now, this is an excellent time for me to repeat, again, I am not an attorney, and this information is not legal guidance of any type. In fact, hopefully it gives you just enough information to convince you that you should call your attorney right now and formulate a plan so you're prepared. Better safe than sorry. So yes, violations are serious, and repeat violations can be even worse, potentially resulting in business license revocations or agreements that allow ICE to monitor your hiring practices for years to come. Something seemingly as simple as over-documentation, asking for more than what's legally required, well, that can actually lead to claims of unfair immigration-related employment practices. You have to treat all employees equally and never target certain employees or groups for additional verification based on appearance or nationality. So simply put, just don't over-document. Now, how do you prepare for all this? Well, again, have a plan. First, train your managers on proper protocols. Make sure they understand that employees have the right to remain silent and not sign documents without legal representation. Set up a clear chain of command for responding to government inspections. Second, engage legal counsel in advance. Designate a point of contact for all ICE interactions, whether that's your HR director or legal counsel. Have an attorney review your I-9s periodically to ensure compliance, and if your industry is frequently audited, consider retaining an immigration lawyer who specializes in this area. Finally, establish a clear communication strategy for your employees. They should know exactly who to contact if ICE arrives. Provide written guidance on how to handle interactions with ICE agents, and this is important. Reassure your team that compliance doesn't mean unnecessarily disclosing their personal information. Remember, being prepared isn't about obstructing justice. It's about protecting your legitimate business interests and the rights of your employees while also complying with the law. The goal isn't to hide anything, but to make sure that the process is handled properly, legally, and with minimal disruption to your business operations. So, take the time now to review your I-9 process, correct any issues that you might find, and develop a response plan. Because when it comes to ICE compliance, an ounce of prevention is worth far more than a pound of cure. If you found this information helpful, please leave a review and tell a friend. Thanks for spending the time. Until next week, same time, same place.